Hello, fellow We the People. I'd like to share with you my thoughts on a peaceful revolution, and the jury is the answer. Before anything can be reasoned upon to a conclusion, certain facts, principles, or data to reason from must be established, admitted, or denied. Ideals rest upon their merits, and if they are good, they most certainly will. The Constitution is to be looked at as a constitution of government ordained and established by we the people of the United States. And what the corporate government of the United States has done to the Constitution is beyond despicable. It's treason. But that's another subject. The state is founded on the relation of rights. Protection is its aim and object. And that protection is but another word for justice, or the obtaining and granting every man his due. Man did not enter into society to be worse than he was before, nor to have less rights than he had before, but to have those rights better secured and protected. It is the duty of the court to afford that protection. Justice is of perpetual obligation and essential to the well-being of every society, as the end intent of law is the happiness and perfection of the general society of mankind. It enjoins upon every person the punctual observance of benevolence and goodwill, as well as justice toward his neighbors. Now everyone must realize all the counties and the cities are actually just incorporated substates, still created by we the people for our protection. They are ours, incorporated by charter with the purpose of protecting us and our rights, not lining the pockets of the bureaucrats with gold. But that is exactly what the bureaucrats have successfully done by hijacking our lower municipal courts through the manipulation of the true power of the jury. Allow me to explain briefly how this was accomplished. You see, back in colonial times, after the Revolutionary War, most of the colonists were highly knowledgeable and studied in the field of law, and they knew their rights. And they also knew the only way to protect those rights was to establish a legal system where a jury of their peers would be the buffer zone between freedom and tyranny. Back then, when trials were conducted, jurors were instructed by the administrators or the justices of the peace that it was their duty to render their decisions using their own moral conscience and conviction based upon the character of the defendant, the nature and circumstances of the allegation, the letter of the law as to how the law was written, and the validity of the law. Was the law a valid one, or did it trespass upon the rights of the people? Back in the mid-1800s, nearing the end of slavery and prior to the beginning of the War of Northern Aggression, many slaves were running for their freedom. When they were caught and prosecuted under the Fugitive Slave Act, due to the moral conscience of the many jurors who were against slavery and the simple circumstance that they were only running for their freedom and the validity of the law, come on, we all know there is no legal maxim that affords one human being the ownership over another human being. So the prosecution of the escaped slaves, for the most part, was unsuccessful. The escapees were set free and not returned to their wealthy owners. The slave owners, in turn, turned and bribed their senators for a resolve. The senators, in turn, held meetings of secrecy with the judges and appealed to them for a solution. That secret meeting was such a success, the judges are still having them today. The solution concurred upon by the judges was to alter the instruction to the jury, instructing them only to render their decisions based on the letter of the law as it is written. We all see today how well that worked by the present state of our current system of law and the millions of America who are imprisoned for victimless crimes, along with those who are indebted to the state by the incurring fines owed for victimless crimes. The vast majority of legal disputes initiated by the police on behalf of their employer, the state, where the plaintiff is the state, the judge, the prosecutor, and the antagonist, who is the police, and the only witness, who is also the police, all represent the same party, the state, and since not one of the elements of a crime, no corpus delicti, the body upon which a crime has been committed, a victim, no mens rea, a guilty mind, a guilty or wrongful purpose, a criminal intent, nor an actor reus, one who has actually committed a crime and been judicially charged as so, can be produced. It doesn't even qualify, according to its own laws, to be heard in a court of law. The state's operation of the court is therefore indistinguishable from that of a criminal cartel, and it's time we take our courts back and put them to use as they were intended for our protection through design by the founding fathers who knew how to repeal and defeat tyranny and oppression. The reason you need to know this is because if you didn't know, every time you're in court, you are either petitioning the courts for redress for damages caused by another party, you're suing them, or you are being sued by another party for damages they claim you have done. And yes, this includes all traffic tickets as well as the other various citations your not so friendly policy enforcement officers so blatantly hand out at will. People, we are all in the jury pool. Eventually, we will all get called to jury duty. When you do, remember, America was and is founded on the common law. To put the conception of it simple, common law is, if there is no victim, there is no crime. Unless someone has received an injury, whether it be physical damage, the loss of life, or the loss of property or damage of property to any and all of his entire wealth, no crime has been committed. A man is therefore free to do his will so long as he keeps his evils and wickedness to himself and does not offend against public rules of decency. He has committed no crime. Jurists, stop being puppets of the corporate thugs by allowing the extortion of your fellow Americans, your brothers, your sisters, your mothers, your fathers, your aunts, your uncles, and your cousins' liberty and livelihood by finding them guilty of corporate bullshit, victimless, no-crime charges, all for the profit of the corporation. Jurists, remember, no victim, no crime, not guilty. And people, unless you have actually injured somebody, stop going into court and pleading guilty to their bullshit lies of a crime. Demand a jury trial. If enough of us do this, the courts will be so overwhelmed with jury trial scheduling, will be near impossible. With enough of the people being in on the jury is the answer, no victim, no crime, not guilty, and refuse to convict on all those legislated victimless crimes, they will be rendered useless to them, being a waste of time and money, and they will have no choice but to repeal the legislated victimless crimes. Come on, people. It's time to unite and fight in the courts established by the Founding Fathers as our weapon against tyranny. We can take our country back one case at a time. Knowledge is the beginning of reason. Reason and ignorance, the opposites of each other, influence the great bulk of mankind. If either of these can be rendered extensive in a country, the machinery of government easily goes on. Reason shows itself, and ignorance submits to whatever it is dictated to it. I have presented the knowledge. It is up to us to put it to reason. With enough people in on the jury is the answer solution, we can bring this corporate government to her knees. Let's make this work. Thumbs up if you like the idea. Share it. And watch my other videos too. Thanks for hearing me out. See ya.